I'm Matt Bishar with Nareit here in Hollywood, Florida for Nareit's REITwise, the 2018 Law, Accounting, and Finance Conference. Joining me today is Sonia Barros, Assistant Director, Division of Corporation Finance with the Securities and Exchange Commission. Sonia, thanks so much for joining us.
Thank you, Matt.
The SEC has been working on an initiative called the Disclosure Effectiveness Project for the past few years. Can you give us an update on the project?
Sure. Before I say anything, I do have to make the standard disclaimer. The views I express today are my own and not those of the Commission or other members of the SEC staff. Disclosure effectiveness, this is a topic that the SEC has been working on for quite some time now, both the Commission and the staff. There have been many Commission actions in this area that have included different things: requests for comments, concept releases, proposing releases. The first Commission action here dates back to 2015. A more recent Commission action was just in October of 2017, and that was proposed amendments to certain items of Regulation SK to improve and streamline those items. And that included things like MD&A and exhibit requirements. But this was not the end of the SEC's disclosure effectiveness story. At the staff level, we are still actively engaged and working on additional recommendations to the Commission for further action here.
And building on that, is there anything that the SEC is working on that would specifically impact REITs?
What I would like to highlight for you today is, as it specifically relates to REITs, is an item that appeared in the Commission's recent Regulatory Flex agenda. And this was published in the fall of last year. That agenda has both short-term and long-term actions. One of the long-term actions is titled Guide 5 Real Estate Limited Partnerships and Form S11. As many know, these serve as the basis for many of the public company real estate industry disclosures. We also have other items. There are the SX schedules, including Schedules 3 and Schedules 4, which apply specifically in the real estate industry. So what does this all mean? What it means is that at the staff level, we are considering recommendations to the Commission to propose amendments to Regulation SK and SX to modernize and streamline real estate industry disclosures. Of course, the timing and content of any proposed amendments would be up to the Commission to decide. And then if the Commission does decide to propose amendments to real estate disclosures, the industry would have an opportunity to comment on those proposals before any final rules are adopted.
Other regulatory developments have been the finalization of the FAST Act and the August 2017 staff policy accommodation with respect to the omission of certain financial statements. Can you give us an overview of those two items and clarify how REITs can avail themselves of these accommodations?
Well, first of all, this applies mostly in the context of IPOs and initial registration statements. And the FAST Act, that was something that Congress passed in December of 2015. With respect to financial statement accommodations, unfortunately, the FAST Act did not extend to Form S11, which is the registration statement forms that REITs would use. It only applied to Forms S1 and F1. However, you mentioned the staff accommodation in August of 2017, and in that, the staff issued guidance where we said that issuers could omit historical financial information from their draft registration statements that they submit to the SEC if they believe that that financial information would not be required when the registration statement is first publicly filed. What's nice about this staff accommodation is that issuers can omit both full year audited financial information as well as interim financial information.
And we understand that the SEC staff continues to be willing to consider SX 3-13 waivers of financial statement requirements. Can you give us some insight into that process?
If you find yourself in a situation where you think that a waiver of required financial information would be appropriate, the best thing to do is to send us a request in writing. It's our division's chief accountant's office that handles those requests. You can email your request in Their email address is dcaoletters@sec.gov. They check that email a couple times a day, so you can be assured that they will get to it in a timely fashion. In terms of some tips for what to include in the request, you should explain the facts concisely. You should not only explain why it's a problem, but also propose a solution. And when you think about your solution, explain why it's a burden to you and why that solution is in the interest of investor protection, because that's what we're thinking about at the staff level when we look at granting those waivers.
And lastly, can you provide us some specifics as to where and when the staff is willing to grant waivers under Rule 314?
Yeah, sure. That's a good question, because 314 financial statements, those relate to real estate operations and the most relevant for this industry. So I'll give you one example. Consider the situation where 314 financials are required for pre-acquisition periods that go several years back, but there are a significant amount of post-acquisition results that are already included in the financial statements. Main things to consider, again, in these waiver requests is that we have to look at the facts and circumstances of each situation. We do want to do what we can to reduce the burden and help transactions move forward quickly, but we also have to think of investor protection and can only grant waivers where they're consistent with that in mind.
Sonia, thank you so much for joining us.
Thank you, Matt.
For more from REITwise, be sure to visit Nareit's website, REIT.com.